about the release of a very masterly book by a very eminent author, Mr. Shri Shantibhushan. Now we know today so many things about it. Namely, you have to be a Batashu, you have to marry a Mitra, then only to become emperor. Well, I must say that Mr. Jha has proved that a bureaucrat can argue things in the Supreme Court more profoundly than the most consummate lawyer. Because he has such intimate knowledge of the subject, and particularly because he has been a very profound reader and a topper, a gold medalist, etc. So if these people put their experience into practice, they can outshine any of the platform. I had a small connection with this case. After the review petition had been dismissed by the Supreme Court, Mr. Jha and Shri Shantibhushan, who were the two petitioners who had filed petitions in the High Court, came to me with the object of filing a curative petition. The procedure requires a senior advocate has to certify that the case is fit for a curative petition. Of course, they knew that I don't easily certify a case as fit for a curative petition. There was no time that I could have gone through the entire thing. Anyhow, I had the benefit of a synopsis. I went through the synopsis, discussed the matter with them, and when I found that one of the grounds in the curative petition was going to be the contravention of the principles of natural justice by the Supreme Court, because of the last day of the Attorney General had handed over to the court some papers without giving prior copies thereof to the other side, and the Supreme Court had used those papers, particularly the opinion of a lawyer whose writings had been given along with that bunch of documents, and that writing by that author was that book had been written subsequent to the High Court judgment while the matter was pending in the Supreme Court. And moreover, that gentleman was a consultant for the counsel who had been representing the government in that matter. And therefore, it was a clear case of contravention of the principles of natural justice, namely not giving an opportunity to Mr. Jha to make his submissions as to what value should be attached to the opinions of that author. Thereafter, I had no hesitation in signing and certifying that the matter was fit for a curative petition. Of course, I always felt that so far, even though the law on curative petition was laid down by Chief Justice Bachao, but I don't think there has been a single case in which any curative petition has been found, and one of the reasons is that in complicated cases, when there is such a long judgment, the burden on the Supreme Court is such that they would find it impossible to admit a curative petition, hear it in court, because the original hearing itself had gone on for a very long time, and of course they couldn't have expected that the hearing in a curative petition, if heard in court, would have taken lesser time. Well, it was a very controversial judgment. The judgment, of course, has given great tribute to Mr. Jha for his scholarship and his assistance that he gave to the Supreme Court. But a reading of the Supreme Court judgment indicates to me that not that they were not convinced of Mr. Jha's argument, but some practical considerations prevented them from accepting his argument. Probably they got the message that if they affirm the High Court judgment, then possibly this inflow of foreign funds from through the Mauritius route will stop. And maybe they got persuaded to believe that it would not be in the interest of the country if so much funds which were coming to the country through the Mauritius route got stopped. That is my understanding, because at one place, Justice Sri Krishna has said in the judgment, he has relied upon the theory of the stare decisis. He has said that in so many judgments, on a different points, a particular view has been taken by the High Courts. It will not be right to disturb that view, although those judgments had nothing to do with the points which had been raised by Mr. Jha. Anyhow, this is an old story. But the research which Mr. Jha had to put in to argue that case, he has utilized in illuminating us on so many issues of constitutional importance, which will go a long way in educating the discerning public and possibly the government also, particularly the point which he has made, that if a treaty is supposed to override the law enacted by the parliament, then it is not right, because you are taking away the power of the parliament. I entirely agree with him on this question, and any treaty to give effect to which will interfere with the laws enacted by the parliament must be approved by the parliament before it is given effect to in preference to the laws enacted by the parliament. I would again take this opportunity of congratulating Shri Jha